Just setting up the projection. You'll be on in just a minute here. Welcome to the fourth and final panel in today's conference. Thank you all for coming. On the monitor through Skype, we have Professor Schauer. Fred Schauer is a professor at University of Virginia School of Law, where he joins us electronically. To my right is Professor Amanda Frost from American University, Washington College of Law. And to my left, Katie Eyer, who is a professor at the Rutgers School of Law in Camden. And we'll begin with Professor Schauer, who will be talking about the extent to which the Constitution, while it still does not appear as a constitutional document, can be potentially made so through various sociological facts and positive interpretation. Professor Eyer will speak next about the extent to which popular invocations of the Declaration of Independence have shifted over time and their relevance for constitutional interpretation within the context of the Declaration's meaning, and she'll explore the historical and contemporary effects on the affirmative action movement and thought. Then Amanda Frost will finish off by discussing the phrase, all men are created equal, and discuss it within the context of a fascinating subject that is rarely mentioned, which is how it affects the immigration law debate and new immigrants' struggle to interpret and to familiarize themselves and to make themselves a part of the American tradition. So let's begin with Professor Schauer.
For the event and for accommodating my schedule. In Charlottesville, Virginia, it does not take very much snow to produce school cancellation, university closure, and as a result, what had previously been an open day became a class makeup day, and I am just coming out of a makeup class. So thank you very much for accommodating me. The question I want to address is somewhat broad, somewhat theoretical. Is the Declaration of Independence part of our Constitution? Is the Declaration of Independence part of our law? And I want to focus on an important point made in different ways by the two great figures of positivist legal philosophy in the 20th century. I realize that great figure in positivist legal philosophy will, to some people, sound like best seafood restaurant in Omaha, but nevertheless, there are important lessons that we can learn from both Hans Kelsen and H.L.A. Hart. Both Kelsen, an Austrian who spent much of the later part of his career at Berkeley, and H.L.A. Hart, who was professor of jurisprudence at Oxford for many years. Both of these figures, in different ways, gave us the same idea. The idea is that law, or what counts as law, ultimately rests on non-legal foundations. Law is, at its ultimate level, what either the people or the officials or perhaps even the army decide to accept as law. So to use an example I have used a number of times in the past, I could write a Constitution of the United States today. It would be entitled the Constitution of the United States. I could provide that that Constitution of the United States would be effective upon my signing of it, and then I would proceed to sign it. As a result, it would just like the Constitution that sits behind 2 layers of glass encased in argon gas at the National Archives, be internally valid. It would look like the Constitution of the United States. It would be an internally valid Constitution of the United States according to all of its own provisions. In that sense, in the logical sense, there would be no difference between my self-written and self-ratified Constitution and the one that sits behind the glass in the National Archives. But of course, my Constitution would not be the Constitution of the United States. The one that sits behind the glass is the Constitution of the United States. But the point of this silly example is to demonstrate that what makes my Constitution silly and what makes what we think of as the real Constitution real is not itself anything about law. It is a pre-legal matter or an extra-legal matter determined by the, call it political, call it sociological, call it something else, fact of acceptance. The American people, American judges, American officials, the United States military, which of course has the ultimate source of power in this country, says that that's the Constitution and my Constitution is not the Constitution, and that's what matters. So in the same sense, that is why the 14th Amendment, or let me go back a little bit further in history, that's why it is plausible to say that the United States Constitution, which was, of course, illegal under British law, is nevertheless the Constitution of the United States. But the Constitution of the United States, illegal under British law, became the Constitution of the United States, became legal, became legitimate, not by anything legal, but it is plausible to say that it became legal and became legitimate at Yorktown. Similarly, we might say that the 14th Amendment, which according to some people, and the arguments are not frivolous, became part of the Constitution of the United States despite the technical difficulties with imposed ratification, became part of the Constitution of the United States at Appomattox rather than anything about technical legal validity or the like. As a result, it could be the case that the Declaration of Independence is part of our law and part of our Constitution. After all, the Declaration of Independence does sit next to the Constitution of the United States in the National Archives as part of a collection of a few documents that the archives call the Charters of Freedom. So in some sense, the fact that the Declaration of Independence, which is behind the same kind of glass and looks the same at a distance, is not part of our Constitution, is not part of our binding law in the way that the Constitution is part of our binding law, is again, and this is the point of my example, a matter of acceptance, a matter of sociology, a matter of pre-legal politics, pre-legal cultural acceptance. Now, it is, of course, true that the Declaration of Independence does not contain prescriptive language. That is, if we compare it to some of the language in the Constitution, there is nothing in the Declaration of Independence that looks officially, formally, and technically prescriptive in the way that no bill of attainder shall be passed is officially, formally, and technically prescriptive. There is nothing in the Declaration of Independence that is prescriptive in the way that Congress shall make no law is prescriptive. There is nothing in the Declaration of Independence that is prescriptive in the sense of creating powers, or to use the language again of H.L.A. Hart, power conferring. So Article 1, Section 8 of the Constitution says, the Congress shall have the power to. And then it proceeds to list all the things that the Congress has the power to do, most saliently, perhaps regulate commerce among the several states and with foreign nations. But it is true that the Constitution contains lots of this law-looking, norm-looking, rule-looking, prescriptive language in ways that the Declaration of Independence, which is more manifesto-looking, more manifesto-sounding, more manifesto-reading, does not. But does that make a difference? I would say probably not. After all, there are some number of other things that do not read in prescriptive terms that nevertheless have risen. Risen might not be the right word, but at least have come to be accepted as part of our law. The Federalist Papers, for example. We could say that in important ways the Federalist Papers are part of our constitutional law, even though they don't read like laws, they don't read like constitutional provisions, they don't read in a prescriptive sense. So the real question then is not whether a document does or does not read in prescriptive language. The real sense, or the really important issue, is whether some document, some item, some writing, some something has come to be accepted as part of the collection of, to use the appropriate technical term, stuff, part of the stuff that we take to be part of our binding law, part of the stuff that we take to be part of the Constitution. As I have suggested earlier, it is probably the case that the Declaration of Independence does not now have that status, but part of my claim is that it could have that status. There is nothing about the formal language of the Declaration of Independence. There is nothing about the process of ratification of the U.S. Constitution that prevents the Declaration from having this status. That is, one could say that at the moment, making a legal argument from the Declaration of Independence does not have the same kind of legal authority, does not have the same kind of legal status as arguing from the Federalist Papers or arguing from the writings of Thomas Jefferson, perhaps on issues relating to the establishment and free exercise clauses of the First Amendment. Or arguing from or citing to the writings of Oliver Wendell Holmes or Brandeis or Cardozo or under some circumstances John Stuart Mill. There are lots of things that have the status of legal authority, that are authoritative sources of our law or sources of interpretation of our law that do not read in normative or prescriptive terms. Conversely, there are some things that look like law, that read like law, that again, because of these pre-legal considerations, have dropped out of the status of being law. So Jamal Green of the Columbia Law School has written influentially about the anti-canon, that is, things that look like law, things that have not been formally repealed or overruled, but nevertheless have dropped out of what it would be respectable to cite in legal argument. Perhaps the best example is Korematsu versus the United States. Another example, until about, here's just a guess, about 8 years ago would have been Lochner versus New York. Lochner has become a somewhat acceptable citation these days, for better or for worse, but as a sociological matter, it's become a somewhat acceptable citation in ways that it wasn't before. One could add Buck versus Bell to this. Holmes' statement about 3 generations of imbeciles are enough. What distinguishes Korematsu Korematsu, Lochner until recently in Buck versus Bell, from, say, Plessy versus Ferguson and Dred Scott versus Sanford, is that Dred Scott and Plessy have been pretty close to formally overruled. Korematsu, Lochner, and Buck versus Bell have not been. But nevertheless, by this pre-legal, extra-legal, sociological process that I am describing, Korematsu, Lochner, until recently in Buck versus Bell, are not parts of our law broadly understood in ways that the Federalist papers, the extra-legal writings of Holmes and Brandeis and Cardozo, and so on, are. So as a consequence, we can say that what counts as legal authority, and therefore what counts as law, I am intentionally collapsing the distinction between law and legal authority. Law is itself an authoritative practice. Law is about what we understand to be authoritative just because of its existence. So what counts as law and what counts as legal authority, and therefore what ultimately counts as law, is a pre-legal or a non-legal matter. As a result, my claim about the Declaration of Independence is that the Declaration could be part of our law, it could be part of our Constitution, it could be part of our ultimate law. After all, it is by no means anomalous, as any Briton will tell you, to talk about the British Constitution or the English Constitution, despite the fact that there is no one single document that they can point to. There are 3 countries in the world at the moment, the United Kingdom, New Zealand, and Israel, that do not have single document written constitutions, but all 3 of those countries believe they have constitutions. In much the same way, we would have a constitution, and we do have a constitution that is both more than and less than the document that finds itself behind the 2 pieces of glass encased in argon gas at the National Archives. Therefore, the Declaration of Independence could be part of our Constitution, could be part of our law. My sociological observation, the sociology of legal argument, the sociology of public understanding, is that the Declaration of Independence is not now part of our Constitution, but there is no formal, logical, legal, or jurisprudential why at some point in the future it could not be. Whether it should be now or sometime in the future is ultimately for the American people and American judges to decide. Thank you very much.
Thank you, Professor Schauer. Clapping from the audience. Thank you very much for that engaging presentation. I have to tell you what's going on there. And you did get laughter, by the way, from the joke that you told right at the very beginning, just because I know you couldn't hear it. Professor Eyer.
Thank you for telling me I'm not a funny guy, so I don't get that much laughter. I need all that I can get.
I should Skype right back to you, and you could see my reaction, or I'd point it towards the audience, but it's too late for that. Okay. Professor Eyer.
Thank you. Good afternoon, everyone. I'm delighted to be here. I know the final panel of the day can be a hard sell, so thank you to those of you who made it thus far. So, unlike a number of the other speakers today, I'm not going to be talking about either whether the Declaration of Independence is law, nor whether it ought to be law. Instead, what I'd like to talk about is a somewhat different perspective, which is what window the Declaration of Independence may give us into the big picture constitutional conversations that are going on all the time among members of the American public. So what is it that the Declaration of Independence and how it is talked about, deployed, and used by members of the American public may tell us about our big picture constitutional conversations around core constitutional values, and ultimately what that may in turn tell us about perhaps constitutional law. And to talk about this, I'd like to focus actually on a particular historical story, which is the historical story of affirmative action. And what I'd like to do is to take you on a tour of how the Declaration of Independence has been invoked in the context of debates over affirmative action, and perhaps what that may tell us. And to get you invested in the story here, I'd like to start with the punchline, which is that invocations of the Declaration of Independence have shifted quite dramatically over time. So today, it is extremely common to hear sentiments like this one, published in the opinion section of the Las Vegas Review-Journal. Quote, "The Declaration of Independence proclaims, 'We hold these truths to be self-evident, that all men are created equal. This is precisely why affirmative action and all that it stands for should be opposed. Affirmative action promotes disadvantaged minorities to levels they may not be qualified for simply because they are minorities. This is inherently racist.'" So this sentiment probably sounds familiar to many of you. It's a common one expressed in the debates over affirmative action today. But 40 or 50 years ago, you would have been much more likely to hear a statement like this one. And please excuse the terminology here. This is obviously not my own language. Quote, "The basic promise of American life, that all men are created equal, must mean, if it means anything at all, that all Americans are assured an equal opportunity to make the most of their individual abilities. That promise has never been kept for Negroes. The color of their skin has meant not only that they are the last to be hired and the first to be fired, but additionally that many doors of opportunity have been implacably closed to them. The so-called Philadelphia Plan, and for those of you who aren't so familiar with the history, this is an early federal affirmative action program, is an attempt to assure Negroes a chance at those jobs, at least on construction projects where the United States government is directly involved." And that's from an editorial from the Washington Post. So you can see in these two statements really deeply divergent perspectives on how it is that the Declaration of Independence relates to the issue of affirmative action. Today, the Declaration is commonly configured, as in the former statement, as being in opposition to affirmative action, whereas 40 or 50 years ago, it was much more common to hear the Declaration invoked, as in the latter statement, as an argument in support of affirmative action's institutionalization. These shifts, of course, have not been categorical. There have always been proponents of both views. But viewed over time, the shift in the proportion of invocations for the pro-affirmative action view versus the anti-affirmative action view have really been quite dramatic. So in the 1970s and 1980s, across all of the contexts of popular engagement that I looked at, so this includes news articles, it includes political invocations, it includes lower court opinions, briefs, at least half, and in certain contexts, much more of the invocations of the Declaration during these early decades are in support of affirmative action. So a majority, and in certain contexts, much more of the ways that the Declaration is being invoked across all of these various contexts is as an argument in support of institutionalizing affirmative action. Today, none of the contexts that I looked at show meaningful representation of this viewpoint. So for example, in the context of political discourse, in the various contexts that I looked at, which included the congressional record, presidential statements, a number of other contexts, there has not been a single invocation of the Declaration of Independence in favor of affirmative action in the last 10 years. The same is true of the lower courts, where invocations have been exclusively in opposition to affirmative action over an even longer time frame, since 1994, so that's greater than 20 years now. In news articles, which are perhaps the best metric of the broad constitutional conversation going on among members of the American public, more than 80% of all invocations of the Declaration today are against affirmative action. And lawyers, in their arguments to the Supreme Court, have invoked the Declaration only once in support of affirmative action in the last 20 years, whereas opponents have done so with regularity. So across all of these various contexts, you see really quite dramatic shifts away from a predominant invocation of the Declaration in support of affirmative action and towards a conception which views the two as deeply opposed. So what happened? What happened to shift the pattern of invocations that we see in this context? To talk about that, what I'd like to do is to take you way back to the 1960s and 1970s, the era when affirmative action first crystallized in the popular imagination as a constitutional concept. And what I'd like to talk about is why, at its inception, it might have made sense to people to understand affirmative action as a fundamentally equality-based program, one forwarding the Declaration's fundamental equality guarantee. And then I'd like to talk just a little bit about what may have changed in the meantime, and ultimately what all this may mean for affirmative action's future as a matter of constitutional law. But starting here with our trip way back, how did the rationales for affirmative action look different 40 or 50 years ago? So today, to the extent that one hears anti-discrimination arguments invoked in the context of the affirmative action debate, such arguments are overwhelmingly invoked in opposition to affirmative action. So again, this is probably a familiar argument, the notion that affirmative action violates the equality rights of whites to be judged without reference to race in the context of educational and employment opportunities. It is, in contrast, quite rare to hear affirmative action defended today as an anti-discrimination measure. So it's common to hear affirmative action defended today as a way of achieving important diversity goals. One sometimes also hears affirmative action defended as a remedy for a history of discrimination, past discrimination. But it is much less common to hear affirmative action described as a means of achieving anti-discrimination in the here and now. But at affirmative action's inception, this dynamic was precisely reversed. So in the late 1960s, discourse over affirmative action quite regularly and directly linked affirmative action to achieving contemporary anti-discrimination goals for racial minorities. So the push to begin counting by the numbers, to look specifically, concretely, at how many minorities held jobs in particular job classifications, which of course were the early origins of workplace affirmative action, began not because of a desire to achieve diversity, but instead because of the recognition of the deep and long-standing resistance among employers to employing racial minorities in many sectors of the United States economy. Regulators, advocates wanted to see concrete results precisely because for so many years, employers had found ways to justify widespread, massive racial discrimination. Similarly, efforts to increase outreach and educational opportunities and training for racial minorities began not, or at least not only out of a sense of remedy owed, but also out of an understanding that centuries of discrimination against a particular community would leave that community less prepared economically and educationally. This conception was perhaps stated most famously by President Lyndon Johnson in an early speech defending affirmative action when he said, quote, "You do not take a person who for years has been hobbled by chains, liberate him, bring him up to the starting line of a race, and then say, you are free to compete with all the others and still justly believe that you have been completely fair." It was these two conceptions of equality, one linked to a recognition of contemporary widespread discrimination, and the other linked to a recognition that the starting point is not fair when preceded by decades of racial subordination, that undergirded the earliest claims to affirmative action. And during this earliest era, it is overwhelmingly in these equality-based terms that one sees affirmative action being defended and put forth. In contrast, the earliest arguments against affirmative action did not sound exclusively or even predominantly in equality-based terms. So one certainly sees some equality-based arguments being made around affirmative action during this earliest era, primarily by traditional supporters of civil rights who simply felt that hard affirmative action, so affirmative action by the numbers, went too far. But one also sees a very different set of arguments arising out of the broader conservative tradition of opposition to civil rights law generally, so sounding in employers' liberty rights, their associational rights to discriminate, and sometimes even in what we would see today as openly racist terms, disparaging the ability of minorities to perform certain jobs. By the mid-1970s, this changed. So by the early to mid-1970s, direct opposition to civil rights was no longer politically acceptable. And so as Mark Graber alluded to earlier today, many of the same individuals who had historically opposed civil rights globally on the basis of these types of liberty and associational rights arguments shifted their discourse to embrace the language of civil rights. And over time, what one sees is that this comes to be the dominant discourse of conservative opposition to civil rights measures, including affirmative action. Today, this argument that affirmative action itself violates civil rights principles of equality has arguably come to be the most widely accepted conception of affirmative action's relationship to equality. Certainly, it is the one that one hears most often articulated in the public debates today. This happened, no doubt, in part because of the effective deployment of this argument by conservative opponents of affirmative action. But there are also reasons to think that proponents of affirmative action and the strategic decisions that they have made have also played a role in how all this has played out. So just as conservative opponents of affirmative action ultimately underwent a shift in their justificatory rationales, so too liberals have undergone their own strategic shift. So in 1978, the Supreme Court decides Regents of the University of California versus Bakke, and the opinion signals that the court's then swing justice, Justice Powell, is receptive to the diversity rationale for affirmative action, but not the equality rationale. The diversity rationale is, of course, much later solidified in the court's case law as a justification for affirmative action. It also turns out that businesses and educational institutions, lots of institutional partners that any movement wants to have on board, were also much more receptive to the diversity rationale than to the equality rationale. And one can see why this would be so, right? Especially the type of hard anti-discrimination rationales that were put forward for affirmative action in this earliest era are quite self-implicating for an institution to endorse. It essentially requires saying, yes, we have engaged in discrimination for a very long time, and these measures are needed to overcome our structural discrimination. So proponents of affirmative action, like its opponents, shifted, but this time away from equality rationales and towards diversity. This may well have made strategic sense, but it has, to some extent, ceded the equality terrain to affirmative action's opponents. It has been many years since the American public has regularly and consistently heard affirmative action defended as an anti-discrimination measure. But during that same time frame, the American public has heard over and over again that affirmative action violates the equality rights of blacks and whites alike. Against this backdrop, we should perhaps not be so surprised to today see the Declaration of Independence and its command that all men are created equal be held up quite rarely in support of affirmative action. Nor should we be surprised that many members of the American public view the two as deeply opposed. To return to our original question, what might this tell us about our broad constitutional conversation, and ultimately perhaps about constitutional law? So obviously, picking out meaning from the broad cacophony of public debates over the Constitution is an uncertain business at best, and it would be foolish to purport to have a clear idea of where constitutional law is going based on all of this. But it is also difficult to dismiss the type of significant shifts that one sees in public invocation of the Declaration in relation to affirmative action as simply background noise. Given how significantly the public does connect core constitutional values to the Declaration, a broad perception that the Declaration's values are divorced from a particular constitutional project seems unpromising for that project's long-term constitutional trajectory. So one way, I think, to understand the Declaration's value in the affirmative action context and perhaps as others, is as a bellwether, as a type of signal of where the American public has come to view a particular project as connected or conversely as in opposition to the Declaration's fundamental constitutional values. And as others have shown, there are reasons to think ultimately that to the extent such shifts are sufficiently pronounced and sufficiently longstanding, that the courts may well follow. So in that way, the Declaration of Independence and its bellwether value may ultimately provide us with clues as to where the law may be going, both for affirmative action and perhaps ultimately for other domains. Thank you.
Thank you so much for that original presentation about such an important subject that is so often in the news. Professor Frost.
Great. Well, first, thanks to Alex for putting this all together and being our fearless leader, and thanks to the National Constitution Center for hosting us today, and thanks to all of you for still being here for what is our very last presentation. Yes, good. I just want to make sure my slides are up before I begin. So my subject today is the Declaration of Independence influence on a constitutional interpretation as it relates to immigration law. And in particular, I want to focus on two subjects. One is the relationship of the Declaration, or the influence of the Declaration on the scope of the Constitution. That is, who does the Constitution apply to? Does it apply only to the citizens of the United States? Does it apply to non-citizens who are living in the United States? And if so, does that include those who are here but unauthorized to be here? Does it apply outside the territory of the United States? These are major constitutional questions which did not have clear answers at the start, at the founding of our nation, and some of which still do not have clear answers. And then in addition, I want to address the effect of the Declaration of Independence on the government's authority over the immigration into and out of the United States. And I think the Declaration speaks on both subjects. The first thing I want to say is I think the Declaration of Independence has a really special relationship to immigration law. First of all, one of our other panelists mentioned this earlier in the day, the Declaration of Independence doesn't consist only of these sweeping statements that we all have heard repeated on July 4th about the rights to equality and to life, liberty, and the pursuit of happiness. It also includes a list of grievances. That is, a list of things the colonists said that the king had done to them that justified breaking free of Britain and becoming independent. And the seventh on that list is the enumerated grievance stating that the king has, quote, endeavored to prevent the population of these states, including by doing things like obstructing the laws for naturalization of foreigners and basically discouraging migration. So there were complaints that the king was preventing the population of the states through the imposition of an unwanted immigration policy on the colonies, and one of the things the colonies wanted to take back for themselves was control over immigration law. And indeed, there's been some debate at this symposium, as well as generally in academic literature, about whether or not the Declaration has legal force and effect. And we've heard lots of debate about that, with I think the majority of people so far today saying it does not carry any legal force or effect, but it might influence interpretation or become a norm that we follow. Well, I'm here to settle the debate. It does have legal force and effect, at least in one fairly narrow way, which is that the Declaration of Independence was the nation's first immigration law. The Declaration of Independence actually has the force and effect of changing the status of changing the status of colonists from being British citizens to being, depending on your perspective, either citizens of the colonies or one citizen of one united body that became the United States of America. And indeed, I've quoted here from a Supreme Court case, Inglis versus the trustees of the Sailor Snug Harbor, where the court said, we date the start of, or the end of British citizenship upon the signing of the Declaration of Independence. So that date actually has legal significance for the United States. And so, at least in that way, it is a document that goes beyond just a speech act, it goes beyond speech and becomes a speech act, something with legal force and effect. So now I want to move on and talk about what will be the bulk of my remarks, which is the focus on the scope of the Constitution. To whom does it apply, and how does the Declaration of Independence factor into the conclusion of whether the U.S. Constitution and the rights and protections it establishes, to whom those apply? So, as I said, there's questions about whether it applies just to citizens within the United States, or whether it includes non-citizens within the United States, including those who may not be authorized to be in the United States or who are in the United States only temporarily. And for those who have thought about this question, and I'm far from the first, there's a number of different theories that can be drawn upon to try to explain the scope of the Constitution. And here I'm paraphrasing and modifying a little bit from Gerald Newman's great book, Strangers to the Constitution. So one theory would be a universalist theory. That is, the rights in the Constitution, the rights in the Bill of Rights, the protections in this great document apply to everyone everywhere. that would be the broadest conception. A much narrower conception would be one about that one would state the Constitution and its rights and protections only applies to citizens of the United States, that it only applies to those people who can claim a formal relationship to the United States as citizens. And then I think a sort of third position, as I said, I'm modifying a little bit here from what others have said, would be a universalist view, but limited by territoriality. That is, the Constitution applies to everyone, citizen or not, authorized to be here or not, but limited to the territory of the United States. And so I think the Declaration of Independence has had some influence on the way in which the Constitution has been read. The Declaration of Independence is very clearly got a universalist rhetoric to it. It says, we hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. I mean, these are not couched in terms of only US citizens get the benefit of this sweeping rhetoric. This is meant for everyone and all of us. These are the natural right themes that we see in the Declaration. The Constitution, however, is less clear about its scope than the Declaration was. So I've put on this next slide the tension in the Constitution's text about whether or not it applies beyond US citizens. So some constitutional provisions seem to support the idea that the Constitution is limited to US citizens. It's the membership or social contract theory I mentioned before. So the preamble says, we, the people of the United States, in order to secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Well, that language, at least arguably, can be read to limit the Constitution's application just to the US citizens within the United States, not to non-citizens. Political rights are also reserved for citizens by the Constitution. The 19th and 26th Amendments refer to citizens being able to vote. Articles 1 and 2 require that one be a citizen to be a member of Congress or president of the United States. But as I said, there's some tension in the text. And indeed, there's quite a number of provisions in the Constitution that speak with the same broad natural rights language, that universalist language, that we saw in the Declaration of Independence. The due process and equal protection clauses refer to persons, not citizens. The Bill of Rights does not refer to citizens. And indeed, even Article 3 gives federal courts jurisdiction over cases involving foreign citizens. So it suggests the Constitution was not meant to be so limited. But this was something that was debated in the early years of the Republic. And the Alien and Sedition Acts of 1798 brought this issue to the fore. There was a number of different things that those laws accomplished, but one of them was the ability of the president to imprison or expel any alien he shall judge dangerous to the peace and safety of the United States. So this was sweeping authority of the President of the United States had to kick any person, any non-citizen out of the United States on the president's conclusion that that person was a danger. And so there was a debate about the constitutionality of this provision. The Federalist supporters of the Alien and Sedition Act espoused a membership or social contract theory of the US Constitution to support this provision. I have a few quotes here that illustrate what I mean. So the first bullet point, aliens are not parties to the Constitution and therefore can claim no benefit under it. Or that last bullet point, we, the people of the United States, so there we are quoting the preamble of the Constitution, we're the only parties concerned in making the Constitution. I find nothing in it which binds us to fraternize with the whole world. So that's Representative Harris Gray Otis saying there's nothing in the Constitution, there's no reason to apply the Constitution's rights and protections to the non-citizens among us. But then we have others, Republicans at the time, who objected to the Alien and Sedition Act and said it does not follow, because aliens are not parties to the Constitution, as citizens are parties to it, that they have no right to its protection. So Madison had this universalist view of the Constitution, which I think, as I said, was mirrored in the universalist language of the Declaration of Independence, that said the rights and protections in the Constitution apply to all, whether or not they are formally parties to the Constitution or not. And in fact, this debate was one that the Supreme Court did not weigh in on immediately, and we saw, with the passage of time, the ratification of the 14th Amendment, which I think, as many have said already today, and as there's a rich academic literature on this, many people think that the Declaration of Independence broad universalist principles were only fully realized and imported into the Constitution with the ratification of the 14th Amendment. So the first major case involving the treatment of non-citizens that came up post the ratification of the 14th Amendment was Aqua versus Hopkins. Aqua was a Chinese citizen who was living legally in the United States, and he challenged an ordinance regulating laundry facilities that was enforced only against Chinese immigrants. This was in an era, especially in California, when there was a lot of racism against the Chinese immigrants, and a lot of laws were targeted at them. The court struck down the ordinance, saying it was applied with an evil eye and an unequal hand against Chinese immigrants, violating the 14th Amendment's Equal Protection Clause. But what's really interesting is how it adopted this universalist view of the Constitution when it did so. And I argue that this universalist view, in part, came from the influences of the Declaration of Independence. That is, that universalist language of the Declaration was now used to read the Constitution to have this universalist application as well. And I put on this slide on your left, a quote from Aqua, and then on the right, the quote from the Declaration of Independence. Aqua, the majority opinion does not cite the Declaration of Independence. It would not come up among Mark Graeber's 22 cases in which the Declaration was cited by the Supreme Court. But the language clearly tracks the Declaration. It starts off by talking about the fundamental rights to life, liberty, and the pursuit of happiness, obviously language very closely tied to the same language in the Declaration. It talks about just and equal laws, referring to the equality principle of the Declaration of Independence. And of course, it concludes that the 14th Amendment, which refers to persons, the right of persons to equal protection, is a universalist law, universalist provision of the Constitution that applies to citizens and non-citizens alike. The court repeated this conclusion outside the context of the 14th Amendment in a case called Wong Wing versus United States, in which Chinese immigrants had been sentenced to hard labor. They were undocumented, unauthorized to be in the United States, and they were sentenced without the benefit of any trial or any criminal process. And they argued this violated their 5th, 6th, and 13th Amendment rights. The United States' response to their legal arguments was that unauthorized aliens such as these did not have any right to constitutional protection. The United States argued in its briefs, none of the Supreme Court cases decided that an alien could sneak or force his way into the United States against their will and stand under the protection of the Constitution. So again, the government says the Constitution, it wants to interpret it with a membership theory, a limited, narrow scope, and the non-citizens here argue the Constitution is more universalist. It should apply to us, even if we're unauthorized. We are in the United States, and we should benefit from it. And the court agreed. It cited to Aqua, which of course was precedent. It said the provisions in this Constitution are universal in their application to all persons within the territorial jurisdiction. And it again repeated that even going beyond the 14th Amendment, the 5th and 6th Amendments applied to non-citizens, even those who are not legally in the United States. A much more recent case, Plyler versus Doe from 1982, again, these same arguments came up. Texas argued, I'll back up for those who are not lawyers and just explain that Plyler versus Doe was a case in which the state of Texas, or maybe just portions of the state of Texas, were trying to exclude unauthorized immigrants from sending their children to the public schools. So if there was an undocumented student, they either couldn't attend the public school or would have to pay extra money to do so. And the challenge, there was a 14th Amendment challenge brought against that law. Texas argued that unauthorized aliens are not persons within the meaning of the 14th Amendment's Equal Protection Clause, and the court rejected this and said they are indeed protected by the Equal Protection Clause. So far I've told a story that seems pretty simple and straightforward. There was a debate about the scope of the Constitution, the Declaration's universalist message won the day, and now we have a Constitution that is interpreted in the same universalist tone as the Declaration to apply to all non-citizens, at least those within the United States. But the story is not that simple, because at the same time that the court was deciding all of these cases that stated that the Constitution applied to everyone in the United States, it was also deciding a series of cases that gave the government enormous authority over immigration law. That is, who could come into and who could be forced to leave the United States. And in a series of cases, the Supreme Court established what's called the plenary power doctrine, which says that the government of the United States has plenary power over immigration to the degree to which it does not have to even be reviewed for constitutionality. So if the government says that somebody is not permitted to be in the United States, must be excluded, the government has almost carte blanche to do that. Che Chan-ping versus United States, a very sympathetic case of a Chinese laborer who'd been in the United States for 12 years. He went on a brief visit back to China. The document I have up here, I'm sure it's hard to read, is his document from the United States government assuring him of his right to return. But while he was away from the United States, Congress changed the law, said no more people from China could come into the United States. He was barred from returning to the land that he'd lived in for 12 years. He challenged the constitutionality of this new law by Congress, and the court rejected his challenge, said that the United States can exclude aliens from its territory. This is a proposition which we do not think is open to controversy. And then I've italicized the next phrase. Jurisdiction over its own territory to that extent is an incident of every independent nation. It is part of its independence. So just as the authors of the Declaration of Independence said we need to control our immigration laws, we need to control who comes in and out of our country, that's essential to our independence, Che Chan-ping draws on that reasoning from the Declaration, not from this universalist human rights message of the Declaration. There was similar other cases, Feng Yue-ting, a few years after, where the court repeated this theme of the government has plenary power over immigration. Even going so far, here I'm showing you a picture of Ignaz Meze. This is a 1953 case. Meze had lived in the United States legally for many years. He left for over a year, and when he tried to come back, he not only was not admitted to the United States, not permitted to come back, but no country would take him. And the United States' position was that therefore he could be held for an indefinite time for the rest of his life on Ellis Island. And that is where he was held for a number of years. And the Supreme Court upheld the United States' argument and again expressed through this plenary power doctrine that the United States had almost complete and total control over immigration law. So as I hope is obvious from my presentation, there's a conflict, a tension between the universalist scope of the Constitution on the one hand and the plenary power doctrine giving the federal government almost complete and total control over immigration with very few constitutional restrictions on the other. And it's created a number of questions that have yet to be resolved, and several of them are either in the Supreme Court right now or are regularly brought to courts. So one of them is, do longtime legal permanent residents, maybe people who've lived in the United States their whole lives almost, if they leave briefly and want to re-enter, do they have any constitutional right to do so? And that's basically an open question. Do U.S. citizens have a constitutional right to bring non-citizen family members into the United States? That's an issue before the Supreme Court right now in a case called Kerry versus Dinn, where a U.S. citizen wife is sued the United States saying it violates her constitutional rights, that they will not give her husband a visa or explain why they won't give him a visa. And the government just argued that case in the Supreme Court, and its view is we have plenary power over immigration. We can do what we want without question. And the case law supports them. We'll see what the Supreme Court does in this case. Does the Constitution limit the power of the federal government to police the borders? This is a major pressing question because it goes to whether, even if we believe the Constitution is a universalist document, is one that applies to everyone within the territory of the United States but not those outside it, what do we do when people come to our borders and then there's a need to police that territoriality? This is a slide from the ACLU talking about the 100-mile Constitution-free zone. There are special rules of constitutional law around within 100 miles of the US border that allow for the kinds of searches and seizures that would normally be unconstitutional. And again, I think this shows the tension between this universalist scope of the Constitution on the one hand and the plenary power over immigration on the other. Obviously, these are not tensions that I can resolve or the Declaration of Independence can resolve. As a country, we'll need to resolve them. But I want to leave you with one last tension that I think the Declaration of Independence creates when it comes to our immigration law and policy and our constitutional approach to immigration. This is a quote from Thomas Jefferson, not from the Declaration, but from writing from 2 years before. And I think he expressed in this quote the general sentiment that we get from the Declaration, which is the sentiment that the founders of our country took the view that the people all people everywhere have a right to leave a tyrannical country and start anew somewhere else, to create a new country for themselves. And that is the essence of this quote from Thomas Jefferson. And of course, it's what those who come to our borders and want entry, whether authorized to do so or not, are trying to do. And I think as a country, we are very conflicted about immigrants, especially unauthorized immigrants, because we recognize that in some ways, the unauthorized immigrants of today are just like the founders of our country who authored the Declaration of Independence. Thank you.
Thank you so much for that excellent presentation. I am going to open up just with a few questions and then open up to the audience. So that my first one is to Professor Schauer. If we're searching for certain pre-legal documents as a basis for constructing social rules, what could those limits be if there's no underlying normative basis? To ask it in a different way, what might limit the use of the Federalist, the Declaration of Independence, or any of these sorts of documents by a tyranny of the majority, such as Holmes allows for in one of his dissents on the First Amendment?
So the short answer to the final way you put the question is nothing. But the more elaborate answer would say, I think we need to distinguish the question of what counts as law for what counts as good law. That itself implicates, again, hundreds of years of debates between so-called positivists and so-called natural law thinkers. But nothing I said, I believe, addresses the, to use your word, normative question of what ought to be or ought not to be recognized as part of our law. So I think largely what I'm trying to say is insofar as a population or its officials or its army decide to recognize as law something that might not contain the word law at the top of it, might not be published in books published by the West Publishing Company. There is no conceptual reason why that could not be law. That's different from the question whether it's good law, and that is different from the question whether the people, the judges, or the army ought to recognize it as law. Both whether it is good law and whether the people, judges, and army ought to recognize it as law are, as you correctly say, normative questions. But the conceptual question is, would it still be law? Part of what I'm trying to suggest is that there may not be anything about the formal nature of the Declaration of Independence that prevents it from being law, just because it doesn't look like the kind of thing that we normally think of as law. And indeed, and I'll stop my answer with this, it's why I would a little bit want to press against those who would draw too sharp a distinction, to use Katie's words, between sources of interpretation of law and sources of law. That ultimately the line between what counts as law and what counts as a legitimate source of interpretation of law is at the very least contested and maybe closer to, in my view, somewhat non-existent. But I don't want to deny the normative dimensions of what we ought to do, but I take that to be a slightly different project from at least mine on this occasion.
Thank you. So, Professor Eyer, that is a nice segue into my question about, is there any means, I mean, I'm thinking of one, but I rather than suggest it, I just leave it that wide open. Is there any means of identifying what is the better or more accurate question? Is it Is it something that's normative? Is it something sociological? Is there any way for someone who is searching for the correct answer to identify whether the historical interpretation of the affirmative action is a better one than the contemporary one?
So I know certainly that you have a particular perspective on this, which is yes. My own perspective is much more as a descriptive observer. I mean, I think ultimately, whatever my own normative beliefs are, and I certainly have my own normative beliefs about which account is correct, that what matters ultimately for the likelihood that any particular understanding of the Declaration is going to influence constitutional law is what the vast majority of members of the American public believe. And to some extent, one could say that has a normative heft insofar as one might hope that normative values inform the extent to which members of the public endorse a particular view. But I think history suggests that's not always the case. I come at it primarily from a descriptive perspective, and I think ultimately from that perspective, what matters is not necessarily what is objectively correct, but rather what is persuasive.
Thank you. So I have a question now to Professor Frost. This goes to something that has been discussed today quite extensively, and I'd like to ask you within the context of immigration, particularly what you said about the Alien and Sedition Act, not only the portion that you spoke about the executive's seemingly unilateral right to determine who would be deported, but also about the length of time until naturalization, which is 15 or 17 years, I don't remember the exact term. This dovetails, I think, into our discussion of why the Constitution, as far as slavery, looks so different than the Declaration. Is there any explanation? Is there an inconsistency there from the Declaration's views on immigration to the Constitution, and then that interpretation into the Alien Sedition Act? Or is there hypocrisy, or does it say something about the way that the people actually viewed it at the time of the Declaration of Independence?
I definitely think there's hypocrisy. I would say not as much hypocrisy as we saw with the very people who owned slaves drafting the language of equality in the Declaration. I mean, that's clearly extraordinary hypocrisy. But I do think there was some hypocrisy because it seemed like some of the very same people who had declared that they had a right to a new and better life, the freedom that comes with self-government, then turned around and denied it to others when the politics changed and the situation changed. And so I do think that there's some hypocrisy there. I also find it interesting, and it's probably for another paper, but there is so little in the Constitution about immigration that it's somewhat shocking. There's no clear authority given to the federal government over immigration, even though that was one of the major issues that led to the Articles of Confederation failing and the need to create this new Constitution. Congress has the power to naturalize, but it does not have an enumerated authority over immigration, and it's been sort of cobbled together as a power they have to realize sovereignty, but it is nowhere in the Constitution. So it seems like a major gap that, for reasons that I don't yet understand, the framers weren't able to address.
And my final question, using a moderator's prerogative, to all three of you. It goes into what Professor Michelman spoke about and Professor Graber as well, and that is how can a lawyer retaining the professional methodology or modalities, to use Philip Bobbitt's terms, use the Declaration in a lawyer's brief or as in oral argument before any level of court? Whoever goes first goes first. I'm not going to assign an order here.
In my opinion, Professor Graber got it precisely right, which is regardless of whether the courts regularly give the Declaration of Independence the imprimatur of law, that indeed people do regularly cite to the Declaration in briefing to the court, and that is a commonly accepted mode of rhetorical argument. So I think that it is, while certainly anybody appearing before the court arguing the Declaration as their basic argument, divorced from a constitutionally founded argument, would not meet the professional norms. I think the ways in which it's used today are entirely consistent with what most lawyers would view as appropriate professional entry points.
And I'll say that I agree with that. And in fact, I thought it was very interesting in Aqua versus Hopkins that the Supreme Court itself relied on the language of the Declaration, but didn't cite it, right? And that's interesting too. So they didn't, I think if they had, Professor Schauer's, it would be part of Professor Schauer's point that they could elevate what they wanted to become a text that is law-like or law. They didn't quite go that far, but they drew on the rhetoric of the Declaration because it is such a powerful normative influence over all of us.
We are at the moment in the middle of an internet-produced dramatic change in what counts as legitimate authority in legal argument, especially on appeal, especially in briefs. It's been pretty well documented that lots of things that are outside of the traditional legal canon are now appearing much more in briefs, much more in appellate court opinions, and much more in Supreme Court opinions than in the past. The leaders of this revolution, if we want to call it a revolution, include Judge Posner, who has written about the fact that he proudly does internet searches to find the information that lawyers should have given him but don't. And Justice Breyer, who with some frequency goes well outside of the existing canon, including outside of things that are in the briefs, outside of things that are in oral argument, outside of things that are in lower court records, to draw on a vast amount of other material. Indeed, perhaps the most dramatic example is Justice Breyer's opinion in Parents Involved, the Seattle-Louisville school case, in which he tasked his clerks to go out and locate a whole range of information about the history of school integration and school segregation in Seattle in particular, none of which was part of the trial record, none of which was in the briefs, none of which was talked about in oral arguments. It seems to me that all of this is a pretty good example of the fact that the traditional boundary that I sometimes jokingly refer to as the difference between stuff in books published by the West Publishing Company and stuff not in those books, that boundary is now crumbling. And if so, the ability to use things like the Declaration of Independence would be thought of as at least less anathema than it would have been in the past.
Thank you. So now I'd like to open it up to the audience, if there are any questions. 1 minute, Fred, we're waiting for somebody to ask. The microphone is coming around.
I'm not sure if this is exactly a question, but lots of people, including you, talked today about the hypocrisy of certain people, but I'm not sure that's the right word. The framers of the Constitution and the people who wrote the Declaration, the upper class, political class of the United States, or whatever it was at the time, were arguing for themselves. They weren't necessarily arguing for the common people who couldn't elect senators because they didn't trust them. And many of the writings talk about not trusting the common people to do the right thing. So I think they really were arguing those grievances and all applied to them, but it didn't apply to the rest of the people. So we're not going to enforce it. So we can have slaves because those grievances didn't apply to them. I'm not sure how the political context of what they do, we seem to be trying to eliminate in a lot of these arguments. The cultural and political context gets ignored in the legal world.
Well, I'll say, first of all, of course, you're right that they lived at a different time with lots of different sort of background assumptions that we don't have today. And maybe they sort of thought those were implicitly written into the language of the documents they drafted. But I also think that they're close enough in time to us, and we can read their letters, their writings, their musings about many things, from their family relationships to their friendships to their political roles. And you know, when they used the language that they did in the Declaration, you know, that all men are created equal, they are endowed by their Creator with certain unalienable rights. That's not language that's qualified, and for good reason. They knew the power of that language was its universalist message, and so I do think there's an hypocrisy there. I'm accusing them of an hypocrisy that, you know, if I'd been alive at that time, I might have been just as guilty of. So I'm not saying I'm a better person, but I do think that they were being hypocritical.
I'm glad you mentioned the all men are created equal, and yet we assume that the Declaration also applied to women to some extent. The Constitution, we also assume it applies to women, although they had to have a special amendment. We had to have a special amendment in order to vote. There are still differences between being a man and a woman in terms of rights with jobs, with pensions, and of course, the biggest issue, which is control of your body. Do we need to have an equal rights amendment or something of that sort, which will say that women actually have control of their body or something to that effect? Or can we rely on past cases, history, maybe enlightenment on the part of the court to rule that women should have control of their body just as men are assumed to have control of theirs?
The moderator was just asked to answer. So the only place that the word male is mentioned in the Constitution is in the 14th Amendment, Section 2. And feminists up until that point, Elizabeth Cady Stanton, Susan B. Anthony, Lucy Stone, consistently argued that both the Declaration, and they often spoke about the Declaration, and the Constitution up until the 14th Amendment applied to women. Although I absolutely agree with you, as a cultural matter, it was absolutely false. In fact, in 1848, Elizabeth Cady Stanton specifically put all men and all women in the Declaration of Rights that she put out from the Seneca Falls Convention. I do think that it probably creates, although I am no psychologist, a subconscious concept about women in some way mirroring men, which is potentially, if I'm correct, then it has deep problematic implications for our society that perhaps only a constitutional amendment would help to rectify.
A little bit as well. I assume, are you referring to abortion when you say a woman's right to control her own body, or?
Thank you. It's not just abortion, but states making requirements of invasive activities into a woman's body, which no one should have the right to do in certain cases, with regard to possibly wanting an abortion and having to have extremely invasive actions, or being able to close clinics which don't perform only abortions but breast examinations and other women's issues. These are all women's issues. It's not just abortion. It's all kinds of activities which support women.
Yeah. I mean, I guess I'd say, I think, formally speaking, the Supreme Court's doctrine already suggests that there is an equality guarantee vis-a-vis discrimination on the basis of sex. And I'm not sure that an equal rights amendment would actually get us any further. What I really see as the fundamental problem is the extent to which people differ on what equality means, right? So I might very much agree with you that equality is not consonant with the actions you're describing, but there are many people who feel that it is, or who feel that there is a countervailing constitutional value that weighs in on the other side. And again, I mean, I probably sound like a broken record, but for me, the sort of crux of these things is the ability to persuade the majority of the American public that your side is fundamentally correct. I'm somebody who believes that constitutional law goes essentially as the public goes. And unfortunately, I don't think that equality as a concept necessarily does the work of doing that persuading.
If I can just come in for a moment. I mean, I agree with then Professor, now Justice Ginsburg, and many others since, who think it would have been better to have decided Roe versus Wade on gender equality grounds than the grounds that it did. And as a consequence, maybe many other things that I think are desirable would have flowed from that. But I also think that Katie Eyer is right in saying that the differences between what an equal rights amendment would do and the current state of existing constitutional doctrine, while not non-existent, are small enough that it may be a mistake to think that a great deal can be done by the difference between the language in an equal rights amendment, at least an equal rights amendment that would look like the one passed by Congress in 1972, and existing doctrine. Which direction to go in is a political strategy question about which I am stunningly ignorant.
Thank you so much. That'll have to be the last word. I am deeply grateful to you for coming and for all those who participated from engaging in this question, and I look forward to the publications.
Thank you. Thank you all for accommodating me.